take away, Marissa.
Thank you. Thank you so much for having me, Chairman Shannon and Chairwoman Shannon. And good afternoon, everyone who's here, members of the General Assembly and people from the community. My name is Marissa Dodson. I am an attorney and I am the Public Policy Director at the Southern Center for Human Rights. We are a nonprofit organization committed to ending mass incarceration, the criminalization of poverty, and the death penalty. We are also committed to strengthening and restoring the state's Indigent Defense Act so that we can make sure that people have what they need who are in the system. We are a collection of lawyers, investigators, and public policy advocates. We do litigation as well as public policy reform efforts at the state and local level. We are significantly interested in House Bill 994. This is the culmination of Governor Kemp's proposals. Hi, Devin. Good afternoon. This is a culmination of Governor Kemp's proposals. As you all know, there has been some discussion over the last year or so about how much crisis our state is in with regards to gang and youth violence. There have been a couple of study committees and task forces that have been put together on this topic. And so we have a few bills that have been introduced that would that are target gang activity. House Bill 994 is the worst one. It was introduced by floor leader and vice chairman of Judiciary Non-Civil Burt Reeves. And also one of the sponsors is the chairman of the Judiciary Non-Civil Committee that this bill went through. When it was first introduced, it had language in it that was quite concerning, including the automatic prosecution of children aged 13 and over for an additional 33 offenses. So for those of you who don't know, SB 440 is the Senate bill that passed years and years ago that basically is the law that allows children to be prosecuted as adults. The list just keeps on growing. We are always concerned every year when someone wants to add an offense to that list of trying kids as adults. It flies in the face of all of the policy proposals that we know about and the data and research and evidence that's out there about young people and brain development. The science says that young people are different and should be treated differently, and so we don't believe there should be SB 440 cases anyway, that no child should be charged and treated as an adult, no matter what the charge itself is, but that is not what this bill had in it initially. The bill also, a couple other things that the bill had in it that it does not have anymore, I should say that, we were able to get rid of that entire section. House Bill 994 today does not have any charges that any additional charges that children will be prosecuted for in Georgia. We avoided that nightmare altogether. Children will still be treated as children when it comes to those 33 offenses. I could go into, I don't know if it makes sense, Chairman, to go into what we've changed at each section, or to run through the problems and tell you what
I think you should, because go through each section, because there's still a lot of information. You know, these bills are very dynamic and they get changed on the fly, and so you may see information online, and again, we don't want you articulating the wrong information, so we're going to go through what the changes were and then also what's still problematic in the bills.
Okay. So if you have a copy of the bill, the section I'm referring to right now is the very first section. So section 1 is the section of the bill that would have required adult prosecution for children. That section has been changed. What that section does now is it requires that we're going to stay in juvenile court. We're going to allow children to stay in juvenile court. But what they have changed is that if a prosecutor in juvenile court wants to transfer a case to Superior Court, they want to have this child prosecuted as an adult. If they file a motion, this bill gives them a automatic right to a hearing in juvenile court. So if the prosecutor says, I think this 13, 14, 15-year-old should be prosecuted as an adult, it's not discretionary by the court must have a hearing. And the court will decide the appropriateness of that transfer. I will say that we think that's a better option than starting in Superior Court, because we allow juvenile court judges who have the most experience with young people, who understand the activity and circumstances of young people in a more particular way, to make a determination as to whether that young person should be treated in the adult system or the juvenile court system. So now section 1 of the bill, instead of trying kids as adults, allows juvenile courts to make a determination as to when children should be prosecuted. The second section of the bill as it was introduced, so now we are on page 2. Let's get over here to it. I need my old summary to look and see what we're changing. So in this section before was, this is actually the new bill. You brought us the new bill.
Yes, this is the
Oh,
bill.
okay, so we don't need to necessarily go through all
No,
the.
we just talked about the sub.
Yeah, okay, good, I'm
Right.
sorry. I
Well,
thought
we
had
just
to-
need to go through some of the top things that were problematic, like what you mentioned about children, because that was what set off the alarm
Yes,
bells about
it
this
did.
bill, and I want people to know that that part has been removed, through the great work of folks who were on the committee, and also advocates like, Marissa, who spoke up to say this is wrong, so.
Okay, thank you, I'm
Yeah.
sorry about that. So in this summary helps us. The summary that you have here will help you go section by section. I just told you what section 1 now does in terms of this juvenile court hearing. Section 2 is about establishing criminal gang activity, or allowing a juvenile court to decide whether or not a child has been involved in, needs additional protections or interventions. And so in section 2, what they're doing is allowing this criteria of evidence of a child participation in a criminal street gang to be considered along with other factors that decide whether the case is transferred. So now we know the juvenile court is hearing, is it appropriate for me to transfer this 13, 14, 15-year-old to be treated as an adult? They now have 12 factors that they consider as to whether or not it would be appropriate to make that transfer. And we have added in section 2 this connection to criminal street gangs. So again, that a court could consider a young person's involvement in gangs if as in their determination as to whether they should be prosecuted as an adult. Section 3, this is actually a good part of the bill. It requires participation in an intervention program for kids who are found to be involved in gangs. So it puts the onus on the Department of Juvenile Justice to develop and implement an evidence-based program for children that are in its custody, so they can be more intentional about trying to reduce gang involvement for young people. So we like the fact that it's evidence-based. We like the fact that it's actually trying to reduce gang involvement, and we like the fact that it's not punitive. Section 4, this is an area that hasn't been changed, and despite all of our efforts. If you don't know already, Georgia has one of the broadest definitions of criminal gang activity in the country. And so this particular section would make our law on criminal gangs even worse, in that it would expand the definition of criminal gang activity to include 4 additional offenses. The first 3 are child molestation, aggravated child molestation, and enticing a child for indecent purposes. There is some conversation right now about the connection between gangs and sex crimes. There is this notion, some people believe that, sex trafficking and sex crimes goes hand in hand with gang activity. That's why we're seeing these 3 offenses show up here as a way to expand the definition of gang activity. They're also including, though, felony obstruction or hindering a law enforcement officer. Felony obstruction is offering or using force when you're being arrested. So to the extent that someone does a little bit more than just words, that says makes the officer angry with words, you're looking at a felony obstruction charge. It's a way to upcharge. A lot of jurisdictions, you'll do anything else while I'm trying to arrest you, I'm going to hit you with that felony obstruction too. Making it a predicate for gang activity is problematic. We raised this with the committee. The members of the committee that were in favor of our position tried their very hardest to get that out. It is still, unfortunately, in the bill. Section 5 is another problematic part of the legislation. Right now, you could be charged and convicted for criminal gang activity if you commit an offense that is to further your membership in the gang, to increase your status, or maintain your status. So I want to join a gang, I want to get higher up in the gang, I just want to stay where I am in the gang. Those 3 things are all captured in 1 count of criminal gang activity under current law. What this bill does is say that instead of having 1 count, we're going to make it 3 counts. We're going to have a count for joining. We're going to have a count for maintaining. We're going to have a count for increasing. Prosecutor said it's unworkable. We don't even like this breaking apart of these offenses this way, because we like to charge them in the alternative. We like to say, we don't care what you believe the person did it for, either because they wanted in, they wanted to stay in, or they wanted to go up. Either way, we like to charge them alternatively. What they're doing now is saying it has to be 3 separate counts. And then on page, let me go fast, sorry. I want to say it's line 249, but it could be different now. 248. And then on line 248 of the bill, which is on page 8, the language says that these offenses it has to be a separate offense, and the offenses shall not merge. So what it means about a lack of merger is that instead of it in the past where you might have 2 or say 3 counts, you would merge them into one so that you could have one sentence. What they're saying now is that it has to be 3 separate convictions with 3 separate sentences, which makes it harder for parole. It encourages additional time incarcerated, and even though the bill does not require consecutive sentencing, so consecutive is when they stack it all together, when they start with so you have 3 counts, you got 5 years on each, you could run it 5 at a time, get 5 and out, or they could do what we call stack, or run it consecutively, and make them all line up together, so you spend 15 years in. The bill does not mandate that. We want to make sure that people aren't saying that it mandates it. But we want to be clear that when you separate out offenses, when you separate out convictions, when you separate out sentences this way, you are encouraging courts to take this action, and we would expect that it would yield more incarceration time for people who are convicted of gang activity. I know it's a wrap. I'm sorry. I'm going to go quickly.
No, you're fine.
Okay, so section 6, so you have section 6 and section 7. I would like to talk about them kind of together, although before I get to section 6 and 7, let me tell you a bad thing that is no longer in the bill that we can thank people like Boddie for getting rid of in the bill. It used to be in this bill that you allowed prosecutors to do what we call venue shop, to decide what part of the state, what county they think they might be able to get the best case in, and prosecute criminal gang activity wherever they wanted to. We have gotten that language out of the bill. There is no venue shopping that can occur now, and so that you will not see that language in the new 994. Sections 6 and 7 are about creating civil actions, allowing the state to, 1, declare people who commit criminal gang activity as public nuisances and allow civil action against them. It really blows up the civil asset forfeiture law. It puts in additional things like allowing a sentencing court to decide that someone couldn't have a license in the future, to have someone divest their ownership of legitimate businesses and corporations. So I say all that to say those sections remain. The civil actions against people convicted of gang activity or alleged to commit gang activity continue. We weren't able to get those parts out of the bill. Section 8. So Section 8 is again this reference to DJJ and their evidence-based intervention program. This again is this requirement that there be some action that is taken. So I'll go back and look at my before what that other section did, because I think I mixed up my sections. But Section 8 is the one that lays out the onus on DJJ to, when they have children in custody that they think are gang involved, to do something more appropriate with them in terms of programming that might reduce gang activity. The final section here, section 9, and then I'll go back up and make sure I have section 2 right, is the sex offender registry. I mentioned to you earlier that somehow we've connected gang activity and these sex crimes is like they kind of go hand in hand. So in addition to all the other things that are in the bill, it also adds 5 new offenses to the list of that require people to register. Notice I do not use the word sex offender. That is a pejorative term. We say people who are required to register on the state's sex offender registry. We've added 5 additional offenses to that list. Burglary with the intent to commit a sexual offense, have no idea what that means or what that will look like in the prosecution of that crime. Prosecutors agreed with us that is problematic. We think that's constitutionally vague and will have some issues. The other one is keeping in place of prostitution, pimping, pandering, and get this, any conduct involving criminal gang activity that involves an underlying felony offense or intent to commit a felony sexual offense. Again, no definition of sexual offense. We think it's problematic that it would have some constitutional issues, but want you to know that those individuals convicted of these offenses will be required to register if this bill were to pass.
Let me, right before you start, so we left these seats in case legislators are going to come in, but I think we're far enough into the meeting that we're probably not going to have more legislators come in. So if you are standing up and you're not recording and you would like to sit, please, you can either come closer or you can take some of these seats.
I figured out what I messed up. Kind of still in the same vein. Sections 3 and sections 8 are about requiring interventions with young people. Sections 3 is about if a child is convicted of or adjudicated for a Class A designated felony. So these are the more serious offenses in juvenile court. If a child is adjudicated of that offense and is connected to a gang, requires programming. If a child is in custody that's been connected to a gang, it requires intervention and programming. So I was kind of right, but I wanted to make sure I made that point clear. Sorry, Whip.
Oh, no.
And so now we're going to have Representative Boddie speak, and I'm not sure what you have planned to say, but I wanted to make a request to see if you could cover with folks, because this is going to be presented as, hey, aren't gangs bad, and don't we need to crack down on gangs? And which nobody in here supports gangs, but Representative Boddie is going to tell you about why this is so problematic and how this could actually reverse us on ending mass incarceration and making the criminal justice reforms that we want to see. You need a sign-up sheet? Yeah.
So thank you so much, Madam Chair. You're absolutely correct. First and foremost, the House Democratic Caucus does not condone or believe in gang activity. However, with that being said, the state of Georgia already has, and I'm not saying, the state of Georgia has the toughest gang statute in their entire country currently. And so it has been advocates for this piece of legislation have stated that Georgia has the toughest gang law in the country, but they don't know if it's effective. So basically we're stating that we have the toughest gang law in the country and we don't know it's effective. But what we do know was effective is the last 8 years of criminal justice reform that the state has been able to see a dramatic decrease in violent crimes and the incarceration of individuals, especially individuals of color, African Americans and Latinos. So we know what works, right? So we know what works, but we know what does not work. And so we're going to a piece of legislation that's going to take us on a path of more incarceration potentially, more youth offenders being incarcerated, juvenile offenders being incarcerated, and at some point in time, if the old bill especially was to be enacted and passed by the General Assembly, at some point in time, more appropriations for prison, more money out of the budget to pay for prisons and for DJJ facilities as well for juvenile offenders. So I just want to give you all that particular overview. But some of the issues that I have with the bill are in line with my learned counsel here. But she testified, Attorney Marissa Dodson testified, as well as other advocates from the Georgia Association of Criminal Defense Lawyers. Macy Lynn and Jill Travis have been stalwarts and allies of ours. Also, the ACLU have been stalwarts and allies, and we have been having war room type of meetings to go through the old bill that we gutted last week, and we met again right after the hearing on Monday. But one of the questions I did ask on page 5, if you look at lines 162, starting at 162 to the next page, on page 6, 170, we were able to find language in the National Institute of Justice where certain states have changed what this means. What is the definition of a criminal street gang? The problem that we have, the biggest problem, and I'll definitely defer to my learned counsel, is the language in line 162, where it says at the end of that sentence, a group of 3 or more persons associated in fact, whether formal and informal, engages in criminal activity as defined by this code section. That is problematic. The reason why, you can have a rap group, you can have just a group of neighborhood kids that all dressed alike, and if they commit a petty crime, say death by shoplifting of bubble gum, they could be considered a gang if they're dressed alike and look alike, wearing the same type of outfit, same type of braids hat, anything. That is problematic. What the National Institute of Justice in California, state of California, have adopted this model is more evidence-based. Okay, has somebody said emphatically that you're in a gang, And is that person in the gang? And have you did anything overtly to declare your affiliation with the gang? Because the problem with this gang statute is that young men and women, or boys and girls, who are wannabes that may see the neighborhood gang members or may have an older brother or cousin, hey, they want to be in gang. They want to be in, and so they're wannabes. And they may act like they're in the gang, but they're not actually in the gang. This current code sucks them into the statute, into a lot of potential prison time as well. So we actually was trying to maybe see, since we're opening the code, that we could change that. Of course, the authors were not friendly to that. They stated that we may be able to try to do that on the Senate side or at a later time. But we feel like if we're going to open up the code, let's open up the code and make it better. If you're going to continue to have the statute on the books. Also, I want you to go to page 6 in section number 5, lines 181 through 186. Learned Counsel stated earlier, in line 82, when it says with the intent to maintain, and lines 185 with the intent to increase his or her status in the criminal street gang. I asked the question point blank to the Republican DA who testified this question, because we had 2 Republican DAs to testify and 2 Democratic DAs to testify. And basically all 4 said this bill has problems. And when I asked the Republican DA, and I'm not trying to be partisan, will you have issues with this particular, with these particular additions to the code? He stated yes. Issues would be if you're trying to present this to a jury, jurors will get confused because it's hard to prove these elements. Essentially, as Learned Counsel just stated, you're adding 3 additional criminal offenses, and the actual elements to prove those offenses are very difficult. So, if a prosecutor was to present and charge through a grand jury indictment these particular crimes, these two additional crimes, they would then have to prove with evidence how you're trying to increase your status in the gang and how you're trying to maintain that status. How do you do that? So what's going to happen if this is actually kept in code? DAs may potentially lose these counts at jury trials. And so down the line, just like happens in the past, someone will come to us and drop a cleanup bill and say the General Assembly needs to clean this up because too many individuals are being found not guilty on those charges. So what we did, the Democratic members of the Judicial Non-Civil Committee, I offered an amendment to strike the language out. The amendment fell on party lines. After the duly elected DA stated that they didn't need that. They felt like the code was strong enough, and they didn't need the language. They felt like the current code, just without this bill, on the current statute that I believe passed back in the, back in the early 2000 or late 2000, 2009, 2010. I don't know the actual when this original crime bill was implemented, but they said we don't need it. We just don't need it. And so when I made the amendment, I stated that in my amendment that we have duly elected prosecutors that are on the front lines every day trying these cases, prosecuting these cases, who have knowledge of these cases, who went to law school to know the law and to prosecute these cases, that are seasoned, and we're not going to listen to them. We're just going to say, you know what, yeah, you all are here, you waste your time. You came down here, your valuable time out of your day to testify, and we're not even going to adhere the advice of experts, because they are experts, because they prosecute these cases in our communities and counties across the state. So that's another major issue that I had with the bill. Also, on page number 8, line 248, Learned Counsel just stated that shall not merge with any offense. So basically what that means, if you have multiple counts, some crimes, I don't want to get too legal in the weeds on it, but you can merge a case because it's legal in fact. or you could merge a case because the facts merge. So you have two mechanisms that counts can merge into each other. And that means that it absorb each other. And what happens is that the potentially the prison time doesn't keep stacking up. And so prosecutors basically stated they don't have an issue with the code as is, the current gang statute, because most of the time when these gang statutes, these gang cases are being prosecuted, prosecutors are charging multiple counts, 10, 12, 15 counts. And so if you have like I would say aggravated assault, 1 to 20, if you got 3 aggravated assault charges, you're looking at 60 years already. But the 60 years can be merged to each other, can be ran concurrent or whatever. But now you got to keep stacking on that, and that can make even more time if you stack that with even more serious charges, say an armed robbery or murder. And so an individual that could get probably 50, 60 years, you see the numbers jump up to 200, 300, 400, 500, 600 years potentially if you got a 24, 26, 30 count indictment. And on paper, you know, it looks like we're tough on crime, but we're not being smart on crime. It just doesn't add up, because eventually a person is going to die in prison. And so what is the end game here? So that was very problematic for me as well. Also, on line 254, one of our Democratic members, very learned attorney himself, one of our newer members, one of our freshman members, stated that we should add the language on line 254 that any person or any case that has been presented to a grand jury, that person commits the criminal gang activity at any property that is within their domain or control could essentially be seized, or because it's a public nuisance. What we're trying to do is have some type of judicial action before we say, okay, you're a public nuisance, or your house is a public nuisance because of the gang activity, and before that property could be declared a public nuisance, and it could be damages, and at some point in time the DA's office could probably move for forfeiture. We just felt like we need some type of judicial action, which is not really judicial. It's a prosecutor presenting a case, getting an indictment, and then you have more of, okay, even though the person is not found guilty of a crime, at least you have a grand jury stating that, okay, it's enough here to formally charge this person with what the police are stating that they did, before we can declare them a public nuisance, and then ultimately charge them treble damages, and ultimately take their property during a civil forfeiture. The last thing I have is again, learned counsel stated this earlier, 360, line 360. My day job, I'm a lawyer. I'm a criminal defense lawyer, so I'm very passionate about criminal justice reform because I was a public defender for 3 years from 2005 to 2008, so in Fulton County. So I've seen some very serious cases. I handled very serious cases. And I have never seen that crime before indicted. I have never seen it indicted before. This is how this is indicted. If an individual breaks into your home, if that individual or defendant commits the act of rape, that person will be charged with burglary, and then that person will be charged with rape. That's you don't have a burglary with the intent to commit sexual offense, because it's like, what does that look like? Like, did the person say that when I broke into your house, that you have to prove that the person broke into an individual's house with the intent to rape the individual or some type of other sexual offense? And I just don't, that's very difficult to prove. It's easy to prove that you broke into the person's house because you went over the threshold, you didn't have consent to be there, and you had the intent to commit a felony therein. And it's easier to prove that you actually commit the crime of rape. But it just doesn't add up. And I know one of the individuals that testified, a former prosecutor, stated that, who was actually for the bill, stated that he only dealt with it one time his whole 30-year career. So it just, it just doesn't make sense because it's not a crime that's typically charged.
Well,
you okay? You okay?
Thank you so much, Representative Boddie. You know, as you can tell, we care a lot about this bill, and you can still hear why it's so problematic. Again, we all know that this country has disproportionately locked up Black and brown folks over time. And right now, you know, we were at a point where Georgia was going in the right direction for criminal justice reform. Now we see where Georgia is not under this new administration, Governor Kemp, and a lot of what they talked about just shows you how things are so loose in here that we could be taking a swipe at individuals' future before they can even get started, in addition to making up crimes that laws already exist on the books in order to be able to prosecute. So again, you're seeing where people are doing, in bills like this, legislators are attempting to do backflips to find ways to additionally incarcerate and to actually expand mass incarceration. So we're gonna start with our sign